كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to lesson 5. Alhamdulillah, we've dealt with a number of cases. There's a few more things to discuss, and inshallah we may be able to complete this chapter in today's session, the rest of the discussion there, inshallah, and then move on to the next one. So having said that, let's the next case scenario, they're very similar to the previous one that we did yesterday or we did in the last session. This is تنازع بعير عليه حمل لأحدهما. So there's a dispute regarding, again, an animal that one of them has some load on, right? So it could be a car and one of them has their possessions in the car, right? Or they've got, so none of them are riding it, none of them are inside it, none of them have the keys for it as such, but one person has, his stuff in the car, his luggage in the car. كذلك الحكم إذا تنازع بعير. If they both disputing an animal, a riding animal, وعليه حمل لأحدهما, one of them has something on it, والآخر قاعد, whereas the other one is the one leading it. So one person could have the keys and the other person has his stuff inside it. فصاحب الحمل أولى. So the person with their luggage on it or in it is actually going to be superior than the person who's just riding it. So I don't think the key one, I think the key one actually means that he's got something. Because if somebody has the keys and the other person doesn't have the keys, then that means that they've got more right, it seems, in the key issue. Right, another one is they are disputing إذا تنازع قميصا أحدهما لابسه والآخر متعلق بكمه فاللابس أولى. The dispute is regarding a shirt, a tunic, a garment. One of them is just holding on, the other one is wearing it, and the other one is just holding on to it, or holding on to the sleeve, for example. Well, obviously the person wearing it seems to be more rightful. This is in the absence of any evidence or anything else to prove otherwise. Right. Moving on to some other issues, inshallah, today. This is going to be a case of sale transactions. The dispute about how much was purchased. I purchased this much. Or how much the price was. I purchased it for £10 or for £15. That's the dispute. Or no, you promised to give me 2 kilos or 3 books. Now I said, no, it's just 2 books. So that's what we're looking at in these cases today, inshallah. So al-ikhtilafu fil bay'i wa thamani, that will be the next set of scenarios that will be inshallah covering today, along with some other cases of deferment. You said you'd pay me in 1 month. I said, no, you gave me 2 months to pay. So inshallah we'll look at that. So it moves on to the next case. وإذا اختلف المتبايعان في البيع أي في ثمن البيع فادعى المشتري ثمنا وادعى البائع أكثر منه أو في قدره بأن اعترف البائع بقدر من المبيع وادعى المشتري أكثر منه أي بأكثر من القدر الذي اعترف به البائع وأقام أحدهما البينة قضي له بها. Very simple case this one is talking about. That let's just say that person A is claiming that he purchased a bag of flour from person B, or 2 books or a pen or something from person B. They both agreed to that much. Now the difference of opinion is that how much is the cost. So person A is saying, I bought it from you for £10. The other one said, no, it was £12. Right? So that's one. One of them has, whoever has proof in that case, a receipt or whatever, £10 or £12, it's going to be judged for them. It's very straightforward, right? This is not a case of both of them having proof. It's just a case of one of them having proof. Then the proof, it's there. It's done, right? Then the other person has to pay. Or it's, you told me you're going to give me, I purchased 2 books of you. The person said, no, it was only 1 book for £10. And the person is claiming, no, it was 2 books for £1. Again, if one of them have proof or a receipt or something, or witnesses there saying, no, you promised him 2 books or you promised him only 1 book, then again, it's going to be judged like that. Because you have proof, and proof is what counts here, and is done and dusted. Now, The issue comes about is if both of them have a different receipt. One is proving 2, one is proving 1 book. One is proving £10, one is proving £12. How can that even come about? Maybe there was an agreement that was made and then it was cancelled, but they didn't tear up and cancel the ticket. It could be for whatever reason it's made up, whatever it is. So, وَإِنْ أَقَامَ كُلُّ وَاحِدٍ مِّنْهُمَا الْبَيِّنَ عَلَى دَعْوَاهُ. They both have evidence. They both have witnesses, right? كانت البينة المثبتة للزيادة أو لا. I like these cases because these are dealt with differently, right? Now, the way you deal with these is that, let's just say it's the case of £10 and £12. What is the point of agreement? That's what you look at. When all other things are equal, right? When everything else is equal, you have to find a way to now give preference to one or the other. So the way to deal with it is find out what the default is. Find out what the agreement is. The agreement is that if I'm saying, if person A is saying that I purchased off you for £10, the other person said no, £12. That means they're both agreeing on at least 10. It's just that the other person is claiming 2 more. Okay? So, let's just say, so he's saying, وَإِنْ أَقَامَ كُلُّ وَاحِدٍ مِنْهُ الْبَيِّنَ عَلَى دَعْوَاهُ كَانَتِ الْبَيِّنَةُ الْمُثْبِتَةُ لِلزِّيَادَةِ أَوْلَى لِأَنَّهَا أَكْثَرُ بَيَانًا وَإِثْبَاتًا. So, whatever the default is, anybody who is claiming more than that and has proof for more than that is going to win in this case. So what does that mean? Let's just say again 10 and 12. So they both, one person has evidence for 10, the other person has evidence for 12. Clearly the evidence for 12 incorporates the evidence for 10, so that's agreed upon anyway. But it also incorporates evidence for 2 more, which the other person can't prove it to be less, because again, could have been that they first agreed on 10 and then they increased it. So the person with the ziyada, with the addition, with the additional, the extra, that person's proof is going to be counted because he is proving something which the other person is not proving. The other person is proving up to 10 anyway, which is similar to person A. Person A saying it's actually 2 more, which is obviously going to be the seller because he's going to want £2 more, and he's proving it. That shows that that shows that additional proof is stronger there, right? Now, in this case, obviously that means the seller, his proof is going to be take precedence. That was if the difference of opinion is obviously with regards to the price. And if it's about 2 or 1 book, then again, they both agree in 1. That means the person who's establishing that is going to be the buyer, who's establishing that, no, you actually sold me 2 books for £10. That person is got proof for that additional book, which the other person has nothing to say for, right? And for him to just say, you only bought 1 book from me, that's enough because the other one agrees, 1 book for sure. But I've got proof, the person is saying, I've got proof to show that it was 2. The other person has no way to reject that. Because to say that you only bought 1 book of me does not reject the fact that you didn't buy a 2nd book of me. Okay? So that's why in that case, it's going to be the buyer whose word will be taken, right? If the difference of opinion is in both things, £10 or £12 plus 1 or 2 books, and they dispute in both, and everybody for their own, what favors them, then in that case, فَبَيِّنَةُ الْبَائِعِ أَوْلَى فِي الثَّمَنِ, then in the case of the price, you're going to take the seller's view of £12, and in the case of the quantity, you take the buyer's perspective, the buyer's claim, which is of 2 books. So it's going to be £12 for 2 books, right? فَإِن لَمْ تَكُنْ لِكُلِّ وَاحِدٍ مِنْهَا بَيِّنَةٌ. What happens if they both making the claim, but none of them have evidence, none of them have proof, none of them have witnesses? So in that case, what we're going to do, they've got a claim, no witnesses. So instead of making them swear the oath, we're going to do a different case, because swearing an oath is a serious matter, right? It's a serious matter. On one occasion, Imam Abu Hanifa was forced to be a judge, and there was a small case that was brought in front of him, and the person bringing the case of the small amount of claim against the other person didn't have evidence. So Imam Abu Hanifa, as procedure, turned to the second person and said, okay, are you willing to swear the oath? And then suddenly he said, you know what, stop. I don't want to force you to swear an oath for something so small. Take Allah's name in such a small issue. That's in vain. I'll just pay for you. I'll just pay him off. So there is that aspect of swearing the oath. So in this case, what they'll do is, فَإِن لَمْ تَكُنْ لِكُلِّ وَاحِدٍ مِنْهُمَا بَيِّنَةً قِيلَ لِلْمُشْتَرِي, it's going to be said to the purchaser, إِمَّا أَن تَرْضَى بِالثَّمَنِ الَّذِي إِدَّعَاهُ الْبَائِعِ, either you agree with what the seller is claiming, £12 instead of 10, وَإِلَّا فَسَخْنَا الْبَيْعِ, let's just make it simple, otherwise we're just going to cancel and annul this transaction between them. And on the other hand, you're going to say to the seller, إِمَّا أَن تُسَلِّمْ, either you're going to give him the two, either you agree to give him the 2 books instead of the one that you're claiming, right? Or we're going to cancel your transaction. Because the whole purpose of it is to just remove the dispute. They can just do a new sale afterwards, a new contract, right? A new sale, right? Let's cancel this one unless they're willing to reconcile. So so this is a way to reconcile it. This is a way to cut the dispute, to get rid of the dispute. So because maybe they want to carry on the contract because they don't want to restart all over again, so they'll just agree. But they can't agree in a way that just fully advantages them in both cases. So either they both get one thing of advantage, one person can't get both advantage, the other person gets fully disadvantaged in this case. So that's what the judge is going to say. Either you deal with it in that way, or otherwise we're just going to cancel it. فَإِن لَمْ يَتَرَاضَيَا, if they don't agree, right? If they both don't agree to it, and the article of sale is still present, they haven't consumed it, they haven't got rid of it, they haven't used it up, and it's still there. The books, in the case of books, they'll still be there. In that case, then you have to, in that case you have to resort to taking oaths, demanding oaths. So استحلف الحاكم كل واحد منه على دعوى الآخر. So in this case, because there's actually 2 cases. One is a case for more of the sale item, and the other one is for more money. So both of them will have to be taking an oath, because they're both of them are claimants and defendants. So one is a claimant from one side and defendant from the other side. However, he will start with the purchaser. He'll start with the buyer. Right? You swear an oath first that you don't owe him 12. You actually only owe him 10. Right? In the Hidayah, it mentions that this is Imam Muhammad's view and Imam Abu Yusuf's second view as well. And it's also a transmission from Imam Abu Hanifa. And this is Sahih. And Isbi Jabi, who's a commentator of the Quduri, he says that you'll start with the Mushtari to take an oath from him first. However, there's another opinion which says that you actually start from the seller instead. And if they both end up swearing the oath, then the Qadi just annuls, because nobody is willing to take responsibility for the addition. So Qadi, the judge, will just cancel the transaction between them, because it just shows that they both swore an oath that, wallahi, I don't know him 12, I don't know him 2 books. They're both saying that means that there's too much ambiguity. You can't have ambiguous sales. Cancel it all out. So the judge will cancel just by them taking an oath. This is a nuanced point. It won't become cancelled just like that. The judge will have to then actively cancel it. That's why it mentions in the Hidayah that the way Quduri has mentioned, Imam Quduri has mentioned it, it indicates that it just won't, just by them mutually taking oaths, both of them, it won't become cancelled automatically, right? It means that it's the Bay'un Majhul. It's going to be an undetermined transaction. So that those are makruh anyway, and they're fasid. So the Qadi has to cancel both of them just to cut that dispute and start again, right? Also, the other way to say that when there's no agreement of how much it was being sold for, the quantity, that means that there's a problem with the actual amount of these things, and no bait can go forward, no sale transaction can go forward with such ambiguity. That's why it's going to be cancelled. Now, if one of them, for example, if any one of them refuses to take the oath, then it means that the case is fine. That particular case. So if the mushtari takes an oath, refuses to take the oath that it wasn't just one book, right? It was actually two books. He's not willing to take the oath, or the two. Either of them refuse to take the oath, then that part of the contract becomes established, right? That claim will become established. So one claim is going to become established, not the other claim necessary, unless both of them are going to be established. So to continue, there's a few other details to this one. If the buyer and seller differ, the next part is وَإِنِ اخْتَلَفَا فِي الْأَجَلِ أو في شرط الخيار أو في استيفاء بعض الثمن فلا تحالف بينهما. If they differ with regards to the credit being for 2 weeks or 3 weeks or 1 month or 2 months, for instance, or whether there was a cancellation clause, meaning money back guarantee, which they call khiyar al-shart, or there was a difference of opinion as to whether a partial payment had been made or not. So out of the £10 you've already paid £2 or not. There's a difference of opinion about that. Now, in all of these cases, as opposed to the previous case, which was about how much the payment was, فَلَا تَحَالُفَ بَيْنَهُمَا, that you can't get them to mutually take oaths in that case. Because they're saying that this is a difference of opinion on a side issue as opposed to the essential elements of the contract and the transaction. And the simple way here is وَالْقَوْلُ قَوْلُ مَنْ يُنْكِرُ الْخِيَارِ وَالْأَجَلِ مَعَ يَمِينِهِ لِأَنَّ الْقَوْلَ قَوْلُ الْمُنْكِرِ. Here you just default to the basic issue that the opinion is going to be the one who's on the default position, and the default position in a transaction is that there is no period, right? Meaning that there is no credit. A normal transaction is just I buy something straight away. Most contracts, sale contracts, do not have credit terms, right? That's an addition. So the default is that person A and person B did a transaction. It's an addition to assume that there was a credit term given along with it, or that there was a money back guarantee, because most contracts, at least in those days, right, and in many places of the world today, don't have money back guarantees. It's only in the West where nearly every store has a money back guarantee, right? But the default is that you don't have money back guarantees. And so the person, that particular one individual who's on the default position, their opinion will be counted as long as they swear an oath. So only one of them will be made to swear the oath, which is the person who is on the default position and not adding the extra. So the claimant obviously is the one who's saying there was a buyback clause or there were credit terms, etc. His opinion, if he doesn't have any evidence, is not going to be accepted. It'll be the other person, because they're on the more default position, because they both agree that the trade took place, and without at least the trade took place. That's an agreement between both of them. Then the claimant is just trying to say that there was also a money back clause on top of it, or there was credit terms on top of it. So it's just going to go back to that default issue. Okay, now until now the discussion was where the item is still present and it hasn't perished, it hasn't been eaten up, it hasn't been consumed, it hasn't been worn out and finished or destroyed. So now he's saying that, let's just say there was a difference of opinion, a dispute with regards to the price after the item perishes. Then there's a difference of opinion. What do you do now? وَإِنِ هَلَكَ الْمَبِيعُ. So let's just say that person A buys a book of person B, and the book أي بعد القبض قبل نقد الثمن. Person A buys the book, received the book, but didn't pay the money yet, right? ثم اختلف, and then they differ. Was it £10 or £12? Again, they can't both be forced to swear an oath in this case, as was the original case where you could. According to Imam Abu Hanifa and Imam Yusuf, the Shaykhain seem to always be together in these cases. Because they're saying that in the previous case where that was the scenario, that was because the book, the item, was still present. Then there's a way to deal with it because you can actually give the book back. But in this case, there's no way to give the book back because it's perished. The buyer had taken possession of it, right? And so he's saying that the way where the case where they both have to take oaths is a very special case scenario that is established through our religious texts, meaning our religious text, and they can't then be transferred to any other place. It has to be about that particular scenario. The Prophet ﷺ mentioned that إذا اختلف so the hadith goes something like this, as mentioned by the author of Hidayah. إذا اختلف المتبايعان, if the buyer and seller, the two parties, transacting parties, differ and dispute about something, وَالسِّلْعَةُ قَائِمَةٌ بِعَيْنِهَا, and the item is present, in its original state, تَحَالَفَ, then they're both told to take an oath, وَتَرَادَّ, and then they just return the transaction to one another. So there's a specific clause there that the item has to be still present. So that's why they're saying that this is a particular scenario where this takes place. So where it doesn't meet that particular scenario, then you can't then you can't then impose. If it doesn't meet that scenario, you can't really impose the mutual swearing an oath, a swearing of oaths. So in this case, it just goes with whoever the default is, they'll just swear their oath and then it'll be done deal. Okay, anyway, going back to this case, if the item is not present and they differ, according to Shaykhain, they don't take oaths because the item is not present, and the opinion is going to be that of the buyer, because the buyer, he'll have to swear the oath to say it was £10 and not £12, because remember, again, out of 10 and 12, the one they both agree to is 10, because 12 contains 10. So they both agree that £10 for sure. It's just that the seller is imposing another £2. The buyer's not agreeing with it. So in this case, you don't have to say to both that, because there's no way of cancelling the transaction because the book was taken by the mushtari or the cake was taken and eaten. So there's no way to return it. So that's why one of them you have to give it to one of them. And the mushtari is the one who's on the default position of 10, because 10 is before 12. 12 is extra and there's no proof for that. So 10, but he just has to swear the oath that wallahi it was 10, and then it would be a done deal, because he's the one who is munkiru ziyadati thaman, he's the one who's rejecting the addition. So usually the opinion is going to be taken of the person who's more on the default and the one who's rejecting the addition, right? The addition is £2 extra. Imam Muhammad, though, he looks at this differently. He says that no, in this case as well, they will both be made to swear the oath, and then after that you'll just cancel the transaction. Okay, if you cancel the transaction, the book is gone, the cake has been eaten, how are you going to give that back? Oh, it's going to be cancelled on the normal value retail price of that. So that is what will have to be given back, right? That does add a level of complexity. Okay. وَإِنْ هَلَكَ أَحَدُ الْعَبْدَيْنِ ثُمَّ اخْتَلَفَا فِي الثَّمَنِ. Now what happens in the case that similar scenario, but there were two items, two slaves were sold, or two garments, two articles of garments, two garments were sold, or two cakes were sold, and one of them was consumed, one of them died, one of them was destroyed. Then they differ with regards to the price. Maybe it happened very quickly, and then they just saw one another and they differed, or somebody told them something and then they differed with regards to the price. Again, according to Imam Abu Hanifa, they will not have to both swear an oath and cancel the transaction, as Imam Muhammad was saying, because again, that particular scenario of swearing in the oath is a very specific scenario according to the hadith where you still have both the items. Here, one of them is lost, so that means it's not, half of it is not present, or some of it is not present, right? Unless he says the seller agrees to ignore that portion which is no longer present, and says, okay, let's just deal with that other aspect like that, then they can mutually do that and cancel that part of the bay, that part of the transaction, and the part that was consumed, then that would be a done deal already. Imam Abu Yusuf, though, his opinion is different from Abu Hanifa this time. He's saying that no, in all cases here, you will swear, they will both swear the oath, and once they've done that, then the contract will be cancelled. With regard in regards to the remaining item, the remaining slave, for example, and it will be like Imam Muhammad said in the previous view. Imam Abu Yusuf seems to follow that view here, that it will be even the part of the non-present item that was consumed or dead or whatever, that will be based on its price. So it will be cancelled, and the price of that will have to be given back. Because so even if person A bought something for 100, but then the value of it was 90, so when they cancel, it would be 90 that they'll have to give it back. And if it was 110, then it'll be 110 that they will have to give back, because they used it up. Essentially, they benefited from it in a sense, so it died in their possession. So that was the opinion of Imam Muhammad. There is some more detail in this regard. I'll just quickly mention that to you. Isbi Jabi, another commentator of Quduri, says that this is how Imam Quduri has mentioned it here, whereas in Al-Jami' al-Saghir it says that the opinion will be actually the mushtari, the buyer's opinion, with regards to the portion of whatever amount has been destroyed, and then they'll only swear an oath with regards to the rest of it, according to Imam Abu Yusuf. Right? And Imam Muhammad saying that they will swear the oath in both cases, and then he'll just return whatever is still there, and he'll have to pay for the perished amount in its qima, in its value now. The opinion that Sahih, he says, is Imam Abu Hanifa's opinion. That is what Mahbubi Nasafi and others have, as Qasim ibn Qutluba has confirmed for us. Imam Quduri then carries on. He says, وَإِذَا اخْتَلَفَ الزَّوْجَانِ فِي قَدْرِ الْمَهْرِ أو في جنسه فادعى الزوج أنه تزوجها ب1000 وقالت المرأة تزوجني ب2000 فأيهما أقام البينة قبلت بينته. I think quite straightforward. If husband and wife have a difference of opinion in terms of how much the mahar is going to be, the dowry is, the husband claims that he married her for 1,000 dirhams or dollars or pounds or dinars, while the woman is saying it was actually 2,000 that you owe me. Whoever among them is able to establish the proof and bring witnesses, then their proof is going to be accepted. Straightforward. Now what happens is, if they وَإِنْ أَقَامَا الْبَيِّنَةِ فَالْبَيِّنَةُ بَيِّنَةُ الْمَرْأَةِ. If they both establish proof, I mean, again, as I said, that these are seldom cases, but if they're both able to establish proof, they both bring witnesses, then as I said, 1,000 is something they both agree to. That's what the husband is saying. Everybody agrees to that. But since for the additional 1,000, which is 2,000, the wife is claiming the addition. So in this case, because there's proof, then her proof is going to be stronger, because she's going over and beyond, because they both agree that 1,000. So the husband's proof only reaches 1,000. The wife's proof reaches 2,000. So that is what's going to be accepted. Okay. وَإِن لَمْ تَكُنْ لَهُمَا بَيِّنَةٌ. Now, if none of them had any proof and there was just a pure mere claim, then according to Abu Hanifa, they would both be told to swear an oath. However, if it was a sale transaction, they would then annul the transaction. In this case, you're not going to annul the transaction. وَلَمْ يُفْسَخِ النِّكَاحِ. In this case, you don't do that, right? Because ultimately, when in marriage, this is not about the marriage itself that there's a difference of opinion. The difference of opinion is only about how much the mahar is, meaning how much the dowry is. So in marriage, we have a situation where if there's a difference of opinion or no dowry was mentioned, then it defaults down to what they call the mahrul mithl, which is usually the average mahr that a woman gets, or the women, based on whatever the women of her family got. So there's always a default that they can resort to, right? Okay. وَلَكِنْ يُحْكَمُ بِمَهْرِ الْمِثْلِ. So that's why he's saying that the judgment will be for a mahrul mithl, which is the average mahr of her family, her female family members. That is what it's going to become stipulated. فَإِنْ كَانَ مِثْلَ مَا اعْتَرَفَ بِهِ الزَّوْجَ وَأَقَلْ قُضِيَ بِمَا قَالَ الزَّوْجِ. So essentially, it's not the mahrul mithl that will be that will be stipulated, but that will be used as the adjudicator, as the arbitrator. So you will see if what the husband has said, if what the husband has said, the mahrul mithl is similar to that, or if it's less than what the husband has said, then whatever the husband has said, that is going to be the 1,000, right? Because clearly it seems to be that what the husband is saying is very similar to what their average is, so that must be right. So that's what we're going to go by, because that's what seems to be apparent. However, if her mahrul mithl, which means her average family mahr, dowry, is similar to the more 2,000 mark, which is similar to what she said, or more than that, then obviously you'll have to go by what she says. So it's going to be more than 2,000, because again, the mahrul mithl is round about what people would stipulate anyway. Right, if the mahrul mithl, her average mahr, is actually in between what she and her husband is claiming, so it's 1,500 for example, then it would be the mahrul mithl itself that would become stipulated in that case. So you disregard what the husband said, what the wife said, you just do the mahrul mithl, which is 1,500 instead, right? And that's because after they both swore an oath, then something else has to be the determining factor. So it's the mahrul mithl in this case. So it's quite, as you can see, it's quite rational the way they approach this, right? Okay, now moving on to disputes with regards to rentals. How much was the rental payment, how many days it was for, etc. وَإِذَا اخْتَلَفَ فِي الْإِجَارَةِ فِي الْبَدَلِ أَوِ الْمُبْدَلِ. So either in the payment or what the usufruct of whatever you are renting, قبل استيفاء المعقود عليه, before you even began to use the house or the car or whatever you had rented. In that case, it's very simple. They haven't even started using anything, so nothing has been used. So tahalafa, they both made to swear an oath. Again, this is the case where they don't have any proof. None of them have proof. They both made to swear an oath, and then after that, it's just both returned, right? So this is just like a sale before anything has been transferred over, so you just cancel it. So it's very, very simple. In this case, the person who is taking the thing on rental, you're going to start with their oath, right? If the difference of opinion is with regards to how much the rental payment was going to be, and the renter who's renting out his house or car, whatever, you'll start with his oath if the difference of opinion or dispute is regarding how many days or how long the rental period was for. Of course, if they both have evidence, so again, both having evidence neutralizes the situation because you can't really go by, then in that case, it'll be the same as the sale case. Whoever's doing the extra, their evidence is going to be heard because clearly they both agree on the lower idea, 2 days instead of 3. Whoever's claiming the 3 days and they're providing evidence for it, we're going to obviously go with that. And if it's to do with the price, then it's whoever is asking for the greater price. However, if they, let's just say that the rental period was over, they had used the product or the place or the car or whatever it is, and then they had a dispute as to how much it was, right? Then in that case, there's no point making them both swear an oath anymore, and the opinion is going to be the renters, meaning the one who had taken the car or the house on rent, the tenant or the driver or whoever it is. It's going to be his opinion. That is what's going to matter, right? If if some period of it was used. So if it was a week's rental and after 3 days or 4 days, that's when they had a difference of opinion. Then in that case, they're both to swear the oath, right? Because remember, there's some period left. So it's similar to the one where they had a dispute before they even started using it. And then in the rest of the period, it will become annulled, and they can do another one if they want. And in what has passed, it will be similar to the previous mas'ala that I just mentioned. وَكَانَ الْقَوْلُ فِي الْمَاضِي قَوْلُ الْمُسْتَأْجِرِ, and in, as he says here, in whatever has already been used, it's the person who took on rent, meaning the one who was paying the rental fee. It's going to be his opinion. I'm going to miss the next part out because that's more about a dispute between a master and his slave, right, in terms of how much the slave has to give. That not really relevant right now, so I'm going to leave that one out. I'm moving to the next one where it says وَإِذَا اخْتَلَفَ الزَّوْجَانِ فِي مَتَاعِ الْبَيْتِ. This is really relevant, very important for us to understand, because this happens a lot, unfortunately. Let's just say husband and wife had a dispute, they're going to separate now, or they're not going to separate, but there's a dispute as to who owns what in the house. A lot of husband and wives, they have common bank accounts, they have common spending, common expenses, and so they kind of treat, whatever the funds are together, and that's a big mistake, because then if there's ever an issue, then it's going to lead to a problem. So you have to be very careful about this. So listen to what they say here. وَإِذَا اخْتَلَفَ الزَّوْجَانِ فِي مَتَاعِ الْبَيْتِ. If there's a dispute between husband and wife, the couple, regarding articles and possessions in the house, furniture, etc., and that could refer to even the gold and silver, right? So it doesn't have to be just furniture and not money. It could be anything. So فَمَا يَصْلُحُ لِلرِّجَالِ فَقَطْ. Anything that is for men, like exclusively used for the male domain, like a male shaver, male clothing, etc., and so on, that obviously is going to be the man's. That can't be the woman's usually, right? And anything that is exclusively for the women, like the khimar, like her head covering and her garments and clothing and so on, then that's going to be for her, because that's obvious. That's what the apparent situation demands. Unless they're both either making, they're a tailor, manufacturer, salespeople, and they're both dealing with male and female clothes, for example, or whatever it is, right? Then that is going to be slightly a different case, because then that is going to come into the category of everything else which could be used for both people. So obviously there's something exclusively men, some things exclusively for women, they're clear. But what about the general furniture, which is for both, or any garments that could be manufactured for both, or unisex garments, or the man is also dealing with female garments because he's got a business to do that, then in that case that goes into that category. So that's what he's talking about, وَمَا يَسْلُهُ لَهُمَا, and whatever can be used for both, like pots and pans and cash and money and everything, then he's saying that فَهُوَ لِلرَّجُلِ, that one is for the man. So to complete this lesson, just to complete that point, whatever is left of that is suitable for both, that could be unisex or that both use it, like everything else in the house that is not exclusively male and female, then that they usually see as the man's. Now the reason behind this is because everything that's there is usually purchased by the man, because the men are supposed to be الرجال قوامون على النساء بما فضل الله بعضهم على بعض وبما أنفقوا من أموالهم, because the men are supposed to be responsible for all the expenses. So the assumption is that everything has been purchased by the man, unless it's something clearly there's proof that he has exclusively given it and gifted it to the wife, and there's some proof for that, then that's obviously clear. But anything which is not, then obviously it's usually is supposed to be the man's, because he's saying that وَمَا يَسْلُهُ لَهُمَا فَهُوَ لِلرِّجَالِ, whatever could be for both, or it's undetermined, then that is usually going to be the man's, because he's what. Now nowadays, especially when women are working, and sometimes they may be even having more of an income, so I mean, there's many things that we could actually do today. We could say that, okay, if they're putting their incomes together, right, and it's 50-50 and their incomes are very similar and they're putting it all in the common pot and they're buying, and everything they bought in the house is from the common pot. In fact, the whole house that they've purchased is also from there. Then clearly that's 50-50 between them. Right, now there could be other situations where the man has just purchased it, but then he said to her, everything here, and there's proof for it, for example, that everything here is for both of us. Okay, then of course, then in that case, it's similar. If one person is providing 60% or 70% of income and the other person is providing 30% of their income, then we could also say that it could be split that way. So there's different ways of doing this. The best thing though for couples is that they make it very clear, right? Unless it's only one person spending and he hasn't said that, you know, I'm going to give you the other half or I'm going to give you a half, then just make it very, very clear that everything is mine, right? Except what I've gifted over to the other partner. So that's very, very important to understand that. There are some other masail related to this. We'll just do one last one to finish off this part of the session. فَإِنْ مَاتَ أَحَدُهُمَا وَاخْتَلَفَ وَرَثَ. This is another scenario that is very common, where husband or wife, one of them passes away, and then their inheritors are asking for all of their assets back. So what do you do in that case? Especially if there's a difference, if there's a dispute now between the inheritors of one of the spouses and the remaining spouse. Again, it's the same thing. Whatever was exclusively men will be for the man. Whatever is exclusively for the women will be for the wife, if she is the surviving partner, or for her inheritors if she has died. Right? So فَمَا يَصْلُحُ لِلرِّجَالِ وَالنِّسَاءِ, and that which is now could be common between them, that is not exclusively one or the other, فَهُوَ لِلْبَاقِي الْحَيِّ مِنْهُمَا. That one, according to what Imam Quduri is saying, is for the surviving partner. So in this case, it doesn't default to the man. It could be for the surviving wife, if that's what the case. سَوَاءٌ كَانَ الرَّجُلُ أَوِ الْمَرْءُ, whether that the survivor is the wife or the husband. Right? The reason is that they are in possession of it. Right? The other partner has died. Let's say the husband died. In this case, the wife survives. It's in her possession. So we're going to assume, unless they have proof, unless the inheritors have proof otherwise to show that it was all the man's, right? Then this is going to be considered to be the surviving partners, even if that's the wife. This is Imam Abu Hanifa's view. Sahibain say that in all cases this should be handed over to the women, whether she's alive or she's the one who's died, right? How much? And again, this is a bit of a loaded issue, but it's related to the fact that in many cultures, women came with equipment, right? Some like pots and pans and some basic stuff. So that's what they're assuming. So again, this is based on custom, I think, right? So saying that all of those things that a woman would normally come with in that particular culture, right? Then those things have to go back to the women. The husband can't take that, but the rest of it will be going to the man. So the bulk of it will go to the man. But anything that in that culture, women usually bring with them, right? In Gujarati cultures, women don't have to bring anything except themselves and they come with their clothes. Even that gets paid for by the husband, right? But in other cultures, not every culture, but in many cultures, the women have to come with something or do come with something. So those things are obviously going to go back there. So it's going to be the urf and the convention that will decide on these things. And people will know what their culture is, go to the ulama of that culture to ask them. That's essential. And then the remaining stuff has to be the husband's. Again, probably because he's the one who's paid for that, right? And there's some other ways of looking at that, especially if there's a divorce, and there's some other opinions that are mentioned by Maidani as well. So yeah, Jazakallahu khairan. We'll see you in the next session.